Is it working? Is anybody here? Post. Is it working? Is it working? Is it working? Is it working? Test, test, test. Small Engine Nation. Hey, T-Man. Hey, Doug. What's going on? Hello, Dave. Yeah? We are doing some interesting. Now, don't forget, thumbs up the video. Thumbs it up. If you don't thumbs it up, then hardly anybody comes in here. Nobody is ever notified or anything like that. So you guys have to make sure you thumbs up the video. Dave, what's going on? Yeah. Live now. Important stuff. Oh, shoot, that's the wrong thumbnail. Oh, well, can't change it now. That's the last thumbnail from the last live stream. Yeah. No one is here. We are just a figment of your imagination. Yeah. Yeah, I'm going to be broadcasting something kind of special here in a little bit. So if you guys share this out on Facebook and thumbs up the video also, and comment, refresh the page, do stuff like that periodically. It'll help get the video out. Because what I'm going to be doing here, you guys, is on the 11th, a few days ago, I went into court. Actually, it wasn't really it was a conference is what it was. It was between me, the judge, and the defense attorneys, the child support defense attorneys. For those of you who have not been around or been in these live streams recently, within the past few months or so, I'm in federal court right now suing child support for under Title 42, 1983, deprivation of rights under color of law. It is it's a civil rights action that is taken when they violate your life or your property or your bad stuff that they do to people. And you're going to hear what the judge thinks. He's going to talk about certain things that I've done wrong in the case. Problems that have been arisen during during my filings and stuff like that, because I'm trying to learn this stuff as I go, which doesn't seem to be doing very well. And he points that out right away. Yeah. I had a heart attack 3 weeks ago due to my stupid diabetic medication. Oh. Dave Wrangler, I'm the first thumbs up. Awesome. Boomer, thumbs up the video. Sweener, you too. When I play the audio to this this conference, it's real echoey because of the way the room is set up, and I've turned the audio down a little low. So when we are listening to it, I'll be muting my microphone because I want to hear it too. And when certain things are said, I'll be pausing the audio and I'll come in and I'll explain to you what he's talking about. Okay? Hey, Caden. Make sure you guys thumbs up the videos. Periodically thumbs up the videos. Need to get a moderator in here just in case somebody starts getting real stupid or whatever. Yeah, but there's going to be, so I'll be playing the audio to the hearing, to this conference, so you guys will be able to hear it too. And he points out, the judge points out certain things that he thinks is gonna happen to lay the foundation here, so you guys understand what you're gonna be listening to. I filed my case. A few weeks later, the attorneys filed a motion to dismiss. That motion to dismiss had certain merits to it on the claims that were in the initial complaint. Okay. Then other filings happened too, and then I went in and I filed a motion to leave, which is leave the process that's normally in place, and to amend my case and fix the errors that everybody else is seeing in my case. So, I submitted that, but part of the stipulations behind that is that before you ask to amend your case, you have to ask defense if it's okay to amend the case. Well, I didn't know that, and I filed the amended case with this one here. Okay? So that way my amended case is in the paperwork. So the judge, what you're going to hear now, this guy that's talking, he's not the judge, he's a magistrate. Okay, so he's not the presiding judge who's going to oversee the case. So my amended case was dismissed for summary judgment, on summary judgment, because I failed the process, failed to follow the process of submitting the amended case. If the judge sees that this amended case is justified and is okay, then he might allow it to be entered into the case, which would mean that this amended case, my amended complaint, will now supersede the original. Okay, which means the motion to dismiss will be washed out, and other findings and stuff that happened before that will be washed out too, which means it'll be more of a solid case. But because I didn't follow the rules and I didn't find out what the rules were until after I did it. See, that's my biggest problem that I'm having in this case, is that it's not the laws and it's not the legal advice that I need, it's the procedural know-how that I'm screwing up on this. You see what I'm saying? And so I'll be starting it here in about 3 minutes or so. Let's see. I'll do it for you, T-Man. Dave Krennic. Hey, Caden, you got you a small town in the house. Wesley Snyder. Haven't seen you around, Wesley, in such a long time. Yeah, Wesley, we're if you haven't heard what's going on, yeah, I'm since 17 I've been studying law, and I've been studying the Constitution and the formation of what's known as Title 42. It's a specialized civil rights action against the Title 40 collection service in our state, which everybody knows as child support. And I've been learning the hell out of all this stuff up until, because I only have 2 years. The statute of limitations on a 1983 is 2 years, so you have 2 years to learn everything you possibly can before you file your case, before an infraction has happened against you. And it's kind of complicated, but so I had 2 years to learn what I could possibly learn, and I crunched the hell out of everything. And there are so many different levels of law I had to study at the same time. Well, I filed my case on the 7th of this year, January 7th of this year, and in federal court, not in state court or not any petty municipality court or anything like that. I went straight to federal court because it's a federal matter. It's deprivation of rights. When your constitutional rights are being violated, the primary forum, the primary court to handle that is a federal court. And you're going to find, as you listen to this, you're going to hear, in my case, in my initial complaint, I've got 14 cause of actions. Well, technically 13. The 14th one is a request for a declaratory judgment. And so the what's happening now is I'm filing my paperwork a little wrong, a little goofy, and a lot of stuff that I've read about 1983 is that if you're suing people who work at one agency, you don't have to serve everybody. You just serve the agency is all you do. But Title 42, 666, which is child support. Yeah, get that? Title 42, 666. Well, that section of the Social Security Act is contractually created when states voluntarily go into that contract with the federal office. It's a voluntary contract. It's voluntary. The state voluntarily goes into it so that way they can get funding from different sources. If they don't go into that contract with the federal office, and they don't accept child support in their state, then they don't get that extra funding from something else. So it's kind of like a double-edged sword. You know, the state can't get certain funding that it wants, which is a lot of funding. They get a lot of funding from this crap. And so they literally create a contract that dicks over all these people, all these fathers out there pimping out children for the sole purpose of increasing the amount of money coming into the state from the federal government, from taxpayers, in essence. And I've got Supreme Court rulings that cited in my case. There's this one Supreme Court ruling, Blessings versus Freestone, and the Supreme Court blatantly says that child support is not for the best interest of children. It's not for the best interest of any individual children or any moms or the custodial parents. It is specifically created so that way the state can get federal funding. It says it right there in the damn Supreme Court ruling, you know, in a sentence, in a paragraph, I mean. So I've got a lot of stuff in my case that I've got cited, and now I've gotten, the other day, the judge sent out, based upon the preliminary, based upon that conference we just went to, he sent out a schedule, because that's what the whole conference was to set up a schedule on how this case is going to keep proceeding. You know what I'm saying? So the point that I'm at now is, this is the schedule that the judge sent out after the 11th of a few weeks ago. This is the schedule right here. This schedule points out what needs to be done by a certain date. So by June 3rd, I have to put in, that's the deadline for amended pleadings and joinder of parties. Now, joinder of parties means you just join other people into the lawsuit. You bring other people into the lawsuit. So I might bring Crystal in on a lawsuit as being a aggravated plaintiff. Aggravated? No, not aggravated. Not aggrieved. Aggressive. That's what it is. An aggressive plaintiff. What an I'm going to bring my woman in as an aggressive plaintiff. But what that means is it's somebody that you're bringing into the lawsuit who doesn't want to be part of it. That's what an aggressive co-plaintiff is. Then the joinder of parties, you know, I might take some of the defendants and bring them together so they're like a family or whatever, you know. And then I got to deal with my amended pleadings. And see, these are all specific types of paperwork that I have to file specifically somehow. And I don't know how to do that. I really don't know how to. I've looked all over on the internet, and everybody talks about this is what it is and this is what it is. Okay, what's the goddamn process then? Well, you know what I'm saying? That's where I'm at. I'm in the section of procedural know-how. What do I file first? What do I file second? Based upon what I file here, what do I file then? You see what I'm saying? That's the only thing that I'm Dave, yeah, District 9. Yep. California, Montana, Washington, bunch of other, you know, the whole west of the United States literally is District 9. Yeah. Oh, I didn't even think of that. Remember that movie, District 9? Oh, yeah. Okay. But anyways, let me see here. Let me jump over. I'm going to jump over to this video URL. Let me see here. Okay, let me jump over here to this video URL. We got 5 thumbs up. We need more. We need more. Reaper, thumbs up this video. Did you change your YouTube name again, Reaper? Yeah. Yeah. So I'll be playing it here in a little bit. When I do play it, I'll be muting my microphone, and then when we get to certain points, I'll explain what he's talking about. Yeah, I'm gonna fire it up at 7:20 my time. It's 7:25. It's 7:23 now. So here in about 2 minutes, And you guys, those of you who haven't thumbs up the video yet, please do so that way this gets out in front of more people. Refresh the page if you have to. Yeah. Now I've already gone in, and when I get ready to play this thing, I've already gone in and I've adjusted the volume down a little bit. Now it's going to be real echoey when he's talking. I'm not too sure how well it will be for you guys to hear me talk, because for some reason my microphone was like the quietest one in the room. Probably because, I don't know, there was a lady who was a court reporter who was, you know, typing stuff out and everything. I think she had adjustments for microphones, and I think she turned my microphone down a little bit because, you know, because I project my voice, you know. But I don't really talk very much during this case. There's some stuff that the judge says that really damn lets me down, you know. And yeah. Right now it looks like the judge, Reaper, do you want to play Destiny later? Yeah, I probably could, Reaper. Yeah, that'd be kind of fun. Once I get done doing the live stream, I'll probably jump down there to jump on Destiny for a little while. There's some stuff. I'm so backed up on Destiny, man. I've got all these dang things, you know, in my itemized list on all these achievements I can do. But it's like, well, crap, you know, which one do I, you know? I don't know. Yeah. It's like everything I'm doing right now, I have to figure out what to do first, whether it's just this case, or whether it's going outside and planting flowers, or whether it's on Destiny, or whether it's, you know, cleaning the kitchen, or what, you know. Blech. Ember, what's going on? I want to join. That'll be cool. Ember, when I get done doing my live stream here, this will probably take about an hour or two, because this audio is a little long. I'm going to be broadcasting the court hearing that I went into on the 11th, a few days ago. I got the audio of the courtroom recording, and then I downloaded it, contextualized it, turned it into an MP3. I also edited out some of the names that are said during the case. I silenced that section, so you'll hear certain areas where all the audio just stops, because I'm suppressing the names of who these defendants are and stuff like that. So I've already gone through and edited that, and then turned it into an MP3, and then I don't know if you guys can see this goofy square that's up right up above my head here. I don't know if you guys can see that little square that's right up there in the but that's the audio right there. So oh well, nope, doesn't look like you guys can see it. I'm on YouTube right now looking at myself, and yeah, I can't see that square. But yeah, okay. Shit, something is going on with my horses. Gotta go check it out, bro. Alright, Dave, go check on those horsies. Reaper, I forgot you don't know my YouTube account. Oh, yeah. Yeah, well, you came in here that one time. You came in here last live stream and you had a different name. It wasn't just Reaper. It was something, Soul Reaper or something like that. Oh, Ember. Oh. Soul Reaper. Oh, no, okay. Soul Reaper and Reaper. You're two different people? Okay. Oh, geez, now I know. I thought you guys were the same person. Read my comment, Team Man Dave. Where is it at? Which one? I don't know, Dave. I don't know. I might be able to, but we don't have any American Civil Liberties Union around in Montana here. We might, but I tried calling him way before I even started this case up, and the guy was never around. I left like 2 or 3 messages on his phone, and he never contacted me back. So, plus on top of that, Dave, I went to one of these websites that talk about be your own lawyer. Well, I contacted them, and then they contacted me back, and I told them, well, yeah, I'm filing a civil rights action against the Title 40 Collection Service in my state, and this is where I'm at in the case, and I need some help with the process and the procedure. Here is my case, and I sent them a copy of my case. Never heard back from them. Never heard back from them. It seems like all these attorneys and all these people that I try turning to who say they can help, the moment they come to find out that you're suing a child support agency, everybody fucking turns into a pussy. Everybody does. They're all pussies. I'm serious. And yeah. But anyways, I'm going to start this audio. And we are going to... Oh, okay. I see you. Okay. So now some of this stuff might be a little hard to understand because they're talking legal stuff. But yeah. Let me go here. Let's do this. Okay, I'm going to mute my microphone. Let me go here. Let's do this.
This, of course, is a time set for a preliminary pretrial conference in Salem versus, I'm going to say, the Montana Child Support Enforcement Division, the Economic Security Service Branch Manager, Laura Doe, and other purported Doe defendants. It is Civil Cause 19-6 Missoula. And, sir, you must be Mr. Sanum?
Sanum.
Sanum?
Yeah.
And you must be Mr. Quinn.
I am, Your Honor.
You said it right the first time.
All right, now you can be seated.
Thank you, Your Honor.
I know there was a motion, I believe, out of the state, if I remember right, to continue this pending, unless I have it mixed up with another case, pending the court's disposition of pending motions for dismissal. I'm conducting this because we always in this court want to get a schedule in place regardless of what motions may ultimately bring about. And so that's the purpose. I'm not, don't want to appear unnecessarily difficult. Mr. I'll say it again, Sanum?
Sanum, yeah.
Sanum. I always have 50-50 chance and I always pronounce them wrong, but a couple things for you. I know you're not a lawyer. Not that that makes that big of a difference. You are entitled to bring this case, and you can go ahead and be seated. It's just when you address the court. I want you to familiarize yourself with the federal rules of civil procedure and the local rules of procedure. I will tell you this, as I think maybe some of the pleadings that have been filed, some of the orders I should say, the court is required to construe your pleadings liberally. That means complaints. That doesn't mean every other document. The point I want to make is you are going to be held in essentially strict compliance with the rules, just as these folks are going to be held in strict compliance with the rules. So make sure you familiarize yourself with that, the time frames you have to respond to motions, and all other matters covered by the rules. The purpose of this conference, these attorneys know, and you may know from reading the rules, is to set a schedule for final disposition of this case. The deadlines that I'm about to give to you, they are essentially cast in concrete, absent some very, very good cause to change these deadlines. So you're going to have deadlines for the completion of the discovery, which we'll talk about, deadlines to amend the pleadings, etc. Both sides have to comply with those. Now, you gave me a schedule, and I'm not sure, was there a meeting, a Rule 26F meeting? Mr. Quinn, maybe I'll ask you, or did you just submit that on your own?
Ultimately, we submitted that on our own. We attempted to have a meeting in March to address many of these issues, but we're unsuccessful.
What do you mean unsuccessful?
We met and discussed things, and then we had continuing discussions.
But you couldn't agree to certain dates and so forth?
That is correct, Your Honor.
Okay, understood. And understand this, Mr. Sanum, and I'm not saying you're to blame here, don't get me wrong. If you can't agree, you can't agree. But then that gives me, actually, I kind of like it, because then I get to impose deadlines. And
Yeah, my mic was turned off. Dang it, I just explained all that. But I forgot to turn my microphone off. Okay, what he was talking about there is during the meeting with the attorneys, we never talked about setting up a schedule, and we never really said anything about meeting back together. See, what they're doing, what's really happening in this case is that the defense, they're drawing this out and only doing what they're supposed to do a few days before the deadline. They always draw all the way out and to wait till the very last minute. So if I file something and they're going to come in and challenge it or do whatever, then they wait till the very last minute. If they're going to submit something into the case that I'm going to have to eventually challenge, then they should have submitted it earlier on so I could challenge it before the deadline. But they're not really doing that. They're not letting everything. Whenever I submit something, I try to submit it. I give myself a deadline of 5 days. I give myself a deadline of 5 days. Even though, like, if something is filed and you got 14 days to file this and this and this, I don't believe in that. I file it within 5 days. 5 days, 5 days, 5 days, 5 days, 5 days. I sit down here and crunch the shit out of this stuff, retype crap up, edit that, edit this, edit that, and then I submit my stuff within 5 days. I give myself 5 days to do whatever I possibly can, if it's an easy enough thing to do. If it's something I got to do a bunch of damn research on it, then I'll try to extend myself out a little bit so that way I can submit something that's meaningful.
Going to impose deadlines here. I will say this to the state, this is not a criticism. The time frame's too long given the nature of this case in my view, so there will be an order issued that will reflect the dates I'm about to tell you, and but I'm going to give them to you today just so you're aware of them. I'm going to require, you mentioned amended pleadings June 1. I'm going to that's fine. I'm going to allow the June 1 time frame for amending pleadings. That pertains primarily to you, Mr. Sainham. Do you anticipate joining any other entities or individuals?
No.
I have a lot of Doe defendants. Are you intending to identify Doe defendants? Do you know what I mean by that?
Yeah.
But let me back up and be fair to you, okay? As it stands now, I've made findings and recommendations with regard to 1983 claims against the state of Montana as an entity. They can't be sued under 1983. There have been 3 claims reserved. Claim number 12, I'm not sure what that is, but I read counts 13 and 14, that you're making a claim against the state of Montana, i.e. the agency CSED, the Montana Child Support Enforcement Division, under the Montana Constitution, correct? Yes?
Yes.
And then I see a declaratory judgment that speaks for itself, but 12, I allowed that to go forward because Mr. Quinn's motion was very, very narrow in scope. Granted it, again, because it's very clear that the state can't be sued under 1980, and that's the only defendant that had before me, arguably. There was also the question on the sufficiency of the service of process. But giving you the benefit of the doubt, which I'm required to do, accepting all allegations of your complaint as true, and the narrow prescription, if you will, of the motion to dismiss, that's why this case is going forward. We're going to talk about some of the substantive matters, at least I'm going to hear from you.
What the judge just said there, he stated that the specific claims, because I've got 14, technically 13, but because they filed a motion to dismiss based upon certain grounds where the state is not an agency that you can sue under 1983, which I've consistently looked through so much stuff, and child support even though it's state administered, or which means it's the state that partakes in it, it doesn't make it a state agency. I know this to be so much true because it's a voluntary act that the states voluntarily go into, and it's not a state agency. So you can sue child support, and if you can't sue them for monetary damages, you can sue a state agency for injunctive relief. Injunctive relief is like a restraining order. It says, these people have wronged me. I want a restraining order where they just leave me alone. That's what injunctive relief is. So the judge is now saying that because in all from 1 to 11, I'm citing CSED or child support in the state is in each one of those sections, and I can't sue child support under 1983. That wipes out all 11 claims. So what's left over is 12, 13, and 14. 14 is for declaratory judgment. The 13th, the number 12 is the hardship that it creates on Crystal, and the other one, number 12, or 12, 13, and 14. So that's the declaratory judgment. That's Crystal, and then number 12, I guess. 12, 13, and 14. 13 is Crystal, and 12 is a due process violation, where all this crap that's been done against me is a violation of due process. Okay, so that's what the judge is saying right now. He's saying that all from 1 to 11 is going to be wiped out of this case because I've got the state agency named in those sections. But now the state agency, but in all those sections, I have the state agency, CSED, and the defendants, the defendants who actually partook in the action of doing it. Okay, but because I've got the state agency in each one of these claims, all these claims are going to fall apart because I have them in there, because I have that agency in there. But in my amended claim, in my amended complaint that I told you guys about, in that amended complaint, I took all that out. I changed everything. And when I changed everything, that made this claim right here moot. It made it no longer have any authority. But the judge is sitting here looking at it as it is now. What he sees now. Not what it potentially can be, but what he sees now. Okay? Ember has 42,302 more subs than you. Ember does? Well, good job, Ember. I'm gonna have to check out your YouTube channel. Does she Ember, do you do walkthroughs and stuff like that? No, you do. Oh, Ember, he has 42. Oh, 42,000. What? I thought I had 41. Huh. Can you believe it or not? There's that many crazy people out there who like to watch my crazy. Okay, so now I'll continue here.
But what I see here is not going to take a long time to get prepared, and if necessary, because I anticipate more motions from the state, and that's understandable given the nature of this. I will not make any prejudgment on those. Any motion might be filed. I'm just anticipating that. So you're going to have the amendment to the pleadings by June 1. I'm not sure there will be any experts utilized in the case. That's up to you at the end of the day. But the expert disclosure for joint disclosure of experts, that means, for your benefit, Mr. Sainum, again, because these folks are in court regularly, that means that any liability expert you may have, and I don't know what that may be, it's hard for me to fathom what it would be, but any liability expert, any damage expert you may have, that's going to be required by July 26. I'm not going to put in a plaintiff's rebuttal. What we do is, and maybe the defense counsel is aware that July 26th will be a joint liability. I don't know that you have any experts on liability, and then if in fact Mr. Sainum identifies a damage expert, you'll have 30 days from the date of that date to identify any damage expert. Discovery. Discovery is going to be concluded by October 11 of 2019. Now the order that I send out is very detailed. It's one that I followed because the judges preceding me had it. I don't particularly like it, but I point this out to you for this reason. There's a quote, track for the unwary, in there. It's all discovery has to be completed by that time. That does not mean that you get to file interrogatories, requests for production, and so forth at that date. It means you have to serve those, you have to serve those sufficiently in advance that the time allowed the adverse party to respond expires on October 11th. So by way of example, if you're going to serve interrogatories, they have to be by September 11th, okay? But the order is very detailed, but I just want to point that one out to you for your benefit, Mr. Sainum. And again, I don't know if I find it hard to believe about experts here, but nonetheless, make sure you familiarize yourself with Rule 26, which requires a detailed disclosure of any retained expert. And again, the rule is very clear, very express. They have to set forth their opinions they tend to express and the basis for those opinions. So don't get caught by just saying, I've got Joe Blow here, he's going to testify. He or she has to file a statement to that effect, okay? Understood?
Understood.
Motions. I'm going to have a motion deadline of November 29 of 2019. And I still have to clear with the presiding judge, Judge Christensen, as to a trial date, but I'm anticipating the trial will be January 17th of 2020. Now I'm going to give you an opportunity to quibble with me if you wish about the schedule, beginning with you, Mr. Sainum. I may not listen very much, but go ahead. I want to say the same thing to the defendant, too. I just don't see, if I understand this correctly, we're dealing with a case where over the years there have been enforcement proceedings undertaken by the Montana Child Support Enforcement Division regarding child support payments that the state contends were due from you to your children. In a nutshell.
In a nutshell, yeah.
Do you disagree with the conclusions, I take it?
Well, yeah, the actions, the whole process, no paternity's ever been established other than through their administrative process, and that's it.
Have you ever, and I'm going to talk to the defense counsel, have you ever pursued this through the courts of the state of Montana?
No.
So you've challenged it through the complete administrative proceedings available under the pertinent regulations and statutes?
Well, they have no administrative process under 303, CFR 303.11. There's no administrative remedies for deprivation of rights, so...
Well, what I'm asking about, let's not say deprivation of rights. What I'm asking is, there were proceedings conducted by the Enforcement Division pursuant to Montana state law, and right?
Right.
And they were adverse to you. You had an opportunity to contest those during the administrative proceedings?
Yeah, I believe so. I believe it was in the paperwork.
Did you ever take an appeal, an administrative appeal? In other words, I'm not entirely familiar with this, but it's pretty much generally what happens. If there's an enforcement decision, then you have a right to challenge that decision at a higher level within the administrative process. Is that correct, Mr. Quinn?
That is, Your Honor.
And how many steps in the administrative process?
This case is a little more complicated than this because it began in Iowa.
And let me interrupt you there. So that's why you're mentioning CFR. which is the Code of Federal Regulations.
right.
Go ahead, Mr. Quinn.
And there were child support orders out of Iowa that the state of Montana, through an interstate process, was attempting to enforce.
Okay. But even though it originated out of the state of Iowa, when Montana attempts to enforce that, is there an administrative appeal available in the administrative process in Montana?
There is, Your Honor.
Did Mr. Sainham avail himself of that?
I'll need to defer to Ms. Pfeiffer.
Okay, Ms. Pfeiffer, thank you.
Your Honor, from my review of the two cases that appear to be at issue, no hearing was ever requested on any of the enforcement actions.
I'm not holding you to this today. I'm just trying to get a feel for this case because it is unusual, and there's some other matters that I want to discuss. In the enforcement proceedings, again, just generally familiar with how that works, not necessarily with this, because we honestly don't see many of this, as you might expect, which is going to bring up a subject we'll talk about. There ultimately is, I believe, recourse in the courts of the state of Montana. Is that correct?
That is correct, Your Honor.
Explain to Mr. Sainham, if you would, please, because this is your forte, how that work comes about.
So, in the state of Montana, things begin in an administrative action, and we have administrative law judges. So, for example, if we said, Mr. Sainham, you owe X amount of money, say, no, I don't. You have an opportunity to then present your case and say, this is why I don't, to an administrative law judge. Then if you disagree with the administrative law judge, then you can go to the district court under what's called petition for judicial review. If you didn't like what the district court judge did, then you could take that to the Montana Supreme Court.
Now, that's a procedure I'm familiar with in general, okay? Now, I'm not binding you to anything here today, but there are certain things I have to make inquiry of, okay? One is, and I'm going to put this question to Mr. Quinn first, because again, you deal with this quite regularly, I'm assuming. Maybe not in the federal court, which is really unusual. What I'm concerned about here is what's called the abstention doctrines, which may apply here. What that means is a federal court.
Okay, what the judge got done explaining there and asking the other attorney about was when they send you out their paperwork, you have the ability to challenge that paperwork, you know, and go into court. And then he explained that if you don't like that decision, then you can go into a circuit court or a district court of the state. If you don't like that decision, then you can appeal it up to the Supreme Court of the state. But the problem with that entire process, so you've got like 3 or 4 different processes, 3 or 4 different courts that you got to go through. The problem with that is that each one of those turns into a year. Each one literally turns into a year, if not longer. So what they do is knowing that you've got 4 years to try to completely appeal this all the way up to the Supreme Court, what happens is they wipe out half of your paycheck, they take your license, they wipe out your bank account, they wipe out all your foundation of your money so you can proceed in these proceedings. That's what they do. That's what this administrative process that this guy is talking about does to people. That's why you will hardly ever hear about anybody out there fighting child support, because they destroy you before you even have a fucking foundation to go anywhere with it. That's why none of you people hardly ever hear anybody about fighting child support, because they come in and they just destroy a person before you can even get to the state level. You understand what I'm saying? And if I would have been thinking about this at that time, I would have said it, but I wasn't. You know, this is the first time I've ever done this kind of stuff, and I can't. It's hard to think on your feet when you're doing something for the first time. So there's that problem. I mean, what the judge is doing now is he's pointing out that there is an administrative process that you can go through. No, there really isn't, because there is no remedy for constitutional rights violations in that system. And I've got a letter here, right here. This is So what the judge is saying is he's saying there are certain procedures out there that you, the person, have to engage in, go through those processes, and if you can't get remedy or you can't seek redress through those processes, then you have the right to bring it into court. But this right here, that's called an exhaustion. You exhausted all your remedies. Well, the thing is that under administrative law and family law, there are no remedies whatsoever for constitutional rights violations. None. Family law cannot hear cases involved on constitutional challenges. I wrote child support a letter telling them that they, where the hell is it now? It was part of my exhaustion. It's part of the exhaustion. Writing them a letter saying, hey, these cases deprive me of life, liberty, property. You know, it's violating my rights. You know, governments are instituted to be a benefit and security for people, not to turn around, destroy their lives, wipe out their bank accounts, take their wages, wipe out their license, do all that bad stuff against you. But they do it. So that's what this case is about. This is a constitutional case. This is, you know, about my rights, about my life, about my liberty, about me being able to do what I goddamn want to do without any third-party collection service coming in and wiping out my bank account and all that other kind of shit. So that's what this case is about. And what the judge is doing right here is he's pointing out that there's administrative remedies for you out there, but you've never taken them. No, there isn't. And if I would have, like I said, if I would have been thinking on my feet and I wasn't afraid to bark at the judge, bark at the magistrate, then I would have said it. But I wasn't thinking fast enough when this was going on.
In some circumstances, should not and actually cannot get involved in certain matters of state regulation. Okay? It's my preliminary question here, preliminary assessment, that an abstention doctrine, particularly one called Colorado River abstention, you may write that down if you choose, that this is a matter, child enforcement is a matter that's highly regulated by the state, and it's a issue that is particularly important to the state. So the court, in assessing whether it should proceed with a case of this nature, I will tell you I'm going to be looking at the abstention doctrines to see, particularly Colorado River, if that applies. Have you ever dealt with that in federal court before?
I have not, Your Honor.
Okay. That's something I'm going to be looking at. I'm not making a decision now, but I just want you to be aware that whenever some issue that is raised by a person in a civil rights case or just in any case in federal court, the federal court has to look to see if it would be infringing upon a matter that's not uniquely but very important to the state. Now, you've only sued the state. The state was operating under the interstate agreement on enforcement of child. That doesn't make it any kind of federal claim to my knowledge. So anyway, I'm going to be looking at, just so you're aware, I may ask for briefing if I have a question, but I am going to be looking at in the first instance to see if this court should proceed forward and arguably interfere with the state's enforcement, okay? And I'm just being straightforward with you. All right, you guys can be seated, and then I have some other questions. Has service of process with regard to the, I know in the order that I entered on April 5.
Your Honor, I have a question about their process.
Their process?
Yeah, if you can go from the family court then into the state court, wouldn't that mean that going through that process, if you didn't like this decision, didn't like that decision, didn't like that decision, wouldn't the Roker-Feldman doctrine apply to that? Because you can't use the courts as a different form of appeal?
Number one, I can't give you legal advice, but I'll tell you with my understanding of the Rooker-Feldman doctrine is that if one goes through a state court procedure, and I'm not necessarily talking about 1983 cases. That's different. But in terms of challenging what the Enforcement Division decided in district court up to the Supreme Court, the Rooker-Feldman would preclude an individual dissatisfied with the decision by the Montana Supreme Court from effectively attempting to get an appeal of that court's decision to a United States District Court. If there's a decision in that regard, it goes to the U.S. Supreme Court if the Supreme Court grants a petition of certiorari. Okay? When you start to get federal claims involved, as 1983 claims, that's a whole different question. Rooker-Feldman doesn't necessarily apply there unless the court construes what's being filed as just a colorable attempt to effect a direct appeal of a state court decision, Montana state court decision. Does that make sense to you?
Yeah.
So my question is, has process been effectively made, or is the state in a position to tell me, can you tell me that you accept the process that thus far has been made? Because you've made another attempt, right, Mr. Salem, to serve Laura Hogan, I believe it was?
Yeah, yesterday. Once I realized that the amended case hadn't gone through and I erred on that, I decided to send them, re-serve them with a notice or letter, a copy of the summons, and a copy of the original complaint.
Okay. Ms. Pfeiffer?
Your Honor, in looking at the service that we have thus far, what I have seen is correct. Well, I have seen personal service on Mr. Quinn for the CSED.
Okay.
That is the only attempt at personal service. Everyone else, from the Attorney General to the Governor to Sheila Hogan, have been sent by certified mail a copy of the complaint, and sometimes a copy of the summons, not a summons addressed to them.
Well, let me interrupt you for a moment. I think we all know, at least because you practice law, I'm here, I used to practice law. As a representative of the state, you can you not say we can accept service? Or am I misguided in that regard?
Well, if the state, because I have inquired on this point,
Okay.
if the state receives a proper waiver of service form, the DPHHS will sign that.
Do you have the authority, or Mr. Quinn have the authority to sign that document on behalf of the state?
No.
Period.
Right,
It has
correct.
to be who? Sheila Hogan? I just want, look, I don't want to sit in the case
Right.
here and piddle, if you will, over service of process because we have a pro se person that's not done this before. I just want to get process done so I can move forward on the time frame I have. If you can't do it, you can't do it. I appreciate that. Maybe you can give him instruction as to what is lacking rather than me getting another motion from one side or the other. What is lacking in terms of the state of Montana acknowledging service so I can go forward on the time schedule that I intend to implement?
I can certainly do that. What we were expecting is, under the rule, a request to acknowledge service
Sure.
using that waiver form, and no one has received those forms.
Do you know what the waiver of acknowledgement form is?
No, I do not, Your Honor.
It's probably
I've read
on,
about it, but I've never.
It's probably on our website. Do you have our website?
Yeah.
Is it, Annie?
Yes.
So if you go to the website www.mtd.uscourts.gov, you will see an acknowledgement of service form. It's self-explanatory. Get it to the individuals that